Spousal maintenance comes up regularly in property settlement discussions, but many people aren't clear on when it actually applies or how long it can last. Under Section 72 of the Family Law Act, 1975, one party is only liable to support the other if two things are true. First, the claiming party is unable to adequately support themselves. Second, the other party is reasonably able to provide that support. Both elements must be satisfied. If either is missing, maintenance will not be ordered. Let's look at need first. The court assesses your income, assets, and earning capacity. Factors like caring for young children, health issues, time out of the workforce, and limited employability can all contribute to a finding of need. But, and this is important, the test is about your capacity to support yourself at a reasonable standard. It is not about maintaining the lifestyle you had during the relationship. On the capacity side, the paying party's income, expenses, and obligations, including to any new family, are all considered. Courts will not make orders that cause genuine hardship to the payer. Beyond that basic test, the court also considers the age and health of each party, whether one party gave up work or career advancement to care for children, the duration of the relationship, the standard of living during the relationship, and whether either party is now in a new relationship. How long does maintenance last? Courts generally favor time-limited orders, enough time for the receiving party to become financially independent. That might be 2 to 3 years while children are young, or while someone retrains. Long-term or permanent maintenance is less common, but it does apply in cases involving older parties, very long marriages, or significant health limitations. Importantly, maintenance orders can be varied if circumstances change. Either party